Hi, I'm Anna Denton-Jones, and in today's Knowledge November, you'll see in the list of things that should go into a service agreement that directors' documents can end up being quite sophisticated and perhaps even lengthy. It's not just a question of taking your ordinary contract of employment or terms and conditions that you might put in place for staff and relabeling it or changing the job description on the top. There are a number of reasons why directors' documents can become quite complicated. Reasons for that might be, firstly, the need to protect the company in various situations and enable it, give it the powers to handle and deal with certain situations, particularly if the directors aren't performing as they should do. It's about protecting the business, perhaps if that person were to become unwell. You'll see later on in Knowledge November how ill health absence dovetails with directors' duties, and you might need to do something in that situation. Other reasons why these documents become quite sophisticated will be around what might happen in the future. So, for example, company might be looking at selling in the future. Any buyer coming in is going to want to do due diligence, and the lawyers advising the buyer will be expecting to see certain things in place to protect the company as regards the employment of the directors. So it makes sense perhaps to put those documents in place now rather than be having to do it at the point of sale. The same will be true of investments. So if the business is looking to raise money, the banks, venture capitalists, investors coming in are going to want to see that certain protections are in place for the company and that directors' service agreements cover various things. So again, worth making sure you put those things in place now. Often what happens in small businesses is that perhaps owner-managers never get round to putting in place service agreements dealing with their employment relationship with the company, which leaves the company in a more challenging position when, for example, problems do emerge. For example, if somebody were to leave, what notice period would they have to give? In the absence of anything else written down, we end up relying on implied terms. And in the case of senior directors, the law is prepared to imply a longer notice period than your Section 86 of the Employment Rights Act, 1 week for every year served kind of thing. You might find that the law would imply 3 months or 6 months notice, but from the company's perspective, do you want to be in that position of having to rely on implied terms rather than something written down? So it's always worth encouraging people to put in place documentation so that the company can deal with things if it needs to. So if anyone's got any questions on Knowledge November so far, please do email me. It's adenton@refreshinglawltd.co.uk.